Take this job and shove it.
I am back. Mike Baumgartner, Jobcast Radio, CEO of the Work-Life Survival Center. Before the break, we were talking about the new, I guess it's a case that's being brought up by the NLRB, the National Labor Relations Board. That's a group of people that essentially, they're sort of the courtroom for the unions. If the company is doing something that the unions don't like, they file a grievance with the NLRB. If a company is having difficulty with the union, they deal with the NLRB. The NLRB is the rule maker for how unions and management essentially legally interact. So they have filed a case regarding an employee who was terminated by bashing her boss on Facebook. And I'm reading from an article. This is off of the McKinney Law Firm, hrlawyersblog.com, November 10th, 2010. And just want to pick up with this. To my knowledge, this is the first time the NLRB or any other agency for that matter has taken such a position in court. The board's position that an employee's activity is in discussing the workplace online is protected concerted activity under the National Labor Relations Act. Generally, the NLRA forbids employers from retaliating against an employee, whether unionized or not, and that's the key here, for discussing work conditions. The board has taken the position that it makes no difference whether the discussion is around the traditional water cooler or around the new digital water cooler, that is social media. Protected activity is protected activity. The NLRB's position would seem to call into question many companies' current social media policies, which forbid making negative postings about the employer on the internet. Arguably, such policies are now illegal under the NLRB's interpretation of applicable law. And remember, this applies to all employers, not just unionized or not. It's going to be a fascinating case to watch. An administrative law judge is scheduled to begin a hearing of the case on January 25th. And according to the materials about this case, it indicates that the Facebook post was responded to by several co-workers who were the employee's Facebook friends. I think this likely bolsters her position considerably. A much more difficult question would be a situation in which an employee makes such a post but has no co-workers as Facebook friends, or has co-workers as friends but cannot establish that any of them saw or were otherwise aware of the posting. What does this mean? It means that the NLRB is saying, look, the labor law says you can gripe about your job. And you can gripe about your job at work. You can be reasonable about it, but you can gripe about it, and that is protected activity. If you are doing it on Facebook as though you were doing it around the water cooler, that is essentially a virtual water cooler, especially if you have friends who are coworkers. And if you're griping about your job in that forum, it's protected, and therefore companies' policies that say you cannot disparage a company on your website is illegal. Now, honestly, I see the point on this. It actually makes some sense. However, what company is going to want an employee who is trashing their employer on a Facebook site? And can you create another Facebook site designed to trash the very company you work for? Do you want them in your doors, or are you going to get them out of the organization and deal with the legalities of it? I imagine this could be huge. This is an interesting case because I have been involved with companies who have had to make the determination to sit an employee down and say, what you said about a particular manager is wrong. Take it down. Don't ever do it again, or you're going to be fired. I have been involved in policy writing with companies who say you are a representative of this guy. And think about this. If you're an employer, you have an employee who is bad-mouthing you. Maybe you're the owner of the company. So somebody's putting on their Facebook page how much you are a mean, evil SOB. And you don't like it. And you're paying that person to work there, but openly express that they think you are a jerk. Do you want that person in your company? Of course you don't. Of course you don't. But now we get into, essentially sort of a freedom of speech conversation. Now, also understand, for me, freedom of speech is freedom of political speech. You really can't say these things about people without repercussions. A company does not have to hire you and pay you while you're bad-mouthing them. That's understandable. That's human nature. But now the government is saying if you post something on your Facebook page and you have coworkers who are responding to that, and you've essentially openly badmouthed your job in the company, which is protected, what is going to happen? This is a fascinating case. We're going to have to see how that comes up. A lot of interesting things going on. Also, the EEOC has issued regulations for what is called GINA. Now, before you start sending me emails saying, what does GINA have to do with my rights as an employee? What is GINA? GINA, which was passed January 9th. It was actually November 21st in 2009. A law was passed. New regulations have finally been written for GINA. GINA stands for the Genetic Information Non-Discrimination Act, which basically states it is against the law for a company to try and find protected, essentially genetic information about you, and they cannot be making hiring, firing, or job decisions based on your genetic information. An extreme case would be the company is beginning to notice that your hair is falling out. They wonder if you are undergoing chemotherapy, and they want to get you out of the organization because they don't want to pay the huge expenses that treating a cancer patient would cost a company in their medical bills. So they go and they find out that, yes, you have a predisposition to cancer. Therefore, we're not going to hire you. Another example would be, and I've heard this expressed before, is that there is considered to be quiet, unofficial discrimination against men who are bald. That bald men have harder times getting jobs than men who have a full head of hair. And therefore, to not hire somebody because they are genetically predisposed to baldness is illegal. And if that's kind of making your head swim, yeah, it does mine too, which is why when they passed this law, everybody's kind of been sitting around wondering exactly what the rules are going to make. Now, the rules have been written by the EEOC about GINA, and they take into effect January 9th of 2011, and people are just beginning to kind of parse them out to see what it means for us, the employee. What it does say is that a company cannot request, require, or purchase genetic information on you or your family with very, very limited exceptions. They cannot go and search the net requesting information concerning genetic information about you, predisposition to diseases, honestly, there are some studies that show predispositioning to theft. There's like a criminal gene, and if you have it, they're not going to hire you. That's the biggest fear that we have. But a company cannot go searching the net to try and find genetic information. They cannot go onto places like Facebook. If they inadvertently discover on Facebook or something conversations regarding protected genetic information, they're not allowed to do that. These regulations are happening. It is also probably going to be forbidding genetic testing of employees as well. And honestly, I think that is good. That's really getting into, trying to determine whether or not a person may or may not have a particular disease, may or may not be predisposed to certain addictions, alcoholism, drug addiction, all that kinds of stuff. It'll be interesting to see how this all plays out. And then, of course, the lawyers will dive in, begin to sue based on GINA and its regulations, and the courts will then reinterpret it, probably in ways never intended by the original people who wrote this back in 2009. But I will keep an eye on it, and I will continue to let you know what it is that you should be aware of. So, interesting things happening in court. Again, we've got the genetic information law that the rules are being written on. We also have bashing your boss on Facebook, protected is it protected? We'll be hearing about that coming up. Lots of other things happening in the labor world. Again, age discrimination is beginning to rear its ugly head. If you feel that you have been, stereotyped because you're over 50, I think you're going to be seeing more and more law cases on that as well. And if you have been, if you feel that you haven't gotten a job because you're over 50, because people think that you're on the downside of your career, and I can't tell you how many times I have been in discussions about whether or not we hire somebody who's over the age of 50, where people say, well, he's kind of on the downside of his career. He's going to just sort of sit back and wait out to retirement. That is a horrifically stupid thing to say about somebody. Companies do it all the time. And if you think that you have been discriminated against, that you didn't get a job because you happen to have gray hair, that is why hair dye for men is selling more than it ever has been. Because baby boomers are older and they got to hide the gray, just like the ladies do, because if you look over 50, you don't get the job. It's absolutely insane. And you're going to begin to see more and more articles. Here's one that I saw on HR The Ladders. Check it out. And by all means, give me a call. If you feel that you've been discriminated against because of your genetics, because whatever the reason is, let's talk about it here on this episode of Jobcast Radio. We are coming to a close. Please feel free to give me a call. 304-867-4142. 304-867-4142. Follow me on Facebook. You can find me on Facebook. Just type in Jobcast Radio. Download my show. Put it on your iPhone, on your iPod. Play it in your car. It is on iTunes, on all the podcast directories. You can also find it off of my website, jobcastradio.com. Check it out. Shoot me an email, mike@jobcastradio.com. We'll see you next week. Bye-bye.
Take this job and shut it.